So we're jumping back into Lisa Allen's testimony to the Post Office Horizon IT inquiry, and the former Post Office investigator says that Horizon evidence, in her view, on its own, even if it showed the shortfall, wasn't sufficient reason to even interview a sub-postmaster under caution necessarily, and that whether that happened would be dependent on what the investigation found and whether the sub-postmaster had any reason that they could provide for the shortfall occurring. This is an interesting departure from what some other investigators have said, so let's listen to what she has to say and jump into the inquiry.
Do you recall there being any time frame within which you were expected to produce your legal report for the criminal law team after a case was allocated to you?
There probably was timescales, but I don't recall what those were.
You say at paragraph 29 of your statement that the financial investigation team also sat within the security operations strand. Is that right?
They did, yes.
And then at paragraph 30 of your statement, you address the work of the casework team. Could we have that on screen, please? That's page 10 of the statement. You say, starting at paragraph 30, also within this strand was the casework team, originally based in London. I can recall Brian Sharkey, Graham Ward, Dave Posnett, and Jason Collins working within this unit at various times until it was relocated to Manchester and Jane Owens became the manager, date unknown. The London casework team managed the case papers between the investigator and the legal services. They were also responsible for, amongst other things, for compliance checks on the files, requesting Fujitsu data, dealing with post office card account inquiries and raising cases. This may be as a result of an audit shortage or if information had been received where suspected criminal offences had taken place. I cannot recall the responsibilities of Jane Owen once the casework team transferred, other than being the Fujitsu liaison point and post office card account inquiries. I do not think she had the relevant experience to compliance check the case papers.
Interesting, because the casework team were responsible, at least in terms of the duties, I think from what we've heard from people who've taken place in casework management, such as Graham Ward, that actually really compliance was their bag. That was their whole reason for being. So it's interesting there to hear a comment that she didn't feel that Jane Owen actually had the experience to compliance check the case papers that were presumably being submitted to her by the investigation teams and their team leaders.
Refer here to the casework team being the Fujitsu liaison point. Is it right, therefore, that any request you made for Horizon data from Fujitsu went through this team?
That's correct, yes.
You address the process which was followed after an audit identified an apparent shortfall, starting at paragraph 40 of your statement. Could we have that on screen, please? It is page 12. Do you say at paragraph 40, after an audit shortage had been reported to the security casework team, it would be assessed as to whether a case should be raised. If a case was raised, then it was allocated to the team leader for that area. The team leader would then assess what response was required and, if necessary, allocate it to an investigator. An investigator would attend the office and try to establish the facts and identify if a suspected criminal offence had or had not taken place. They would identify persons of interest to the investigation. If a suspect was identified, they would be cautioned and, depending on the circumstances, request voluntary searches and attendance at interview. You deal with the steps which would be taken once a case had been raised at paragraph 44 of the statement, which is on page 14. You say once a case had been raised and assigned to an investigator, the stakeholder, contracts manager, would be informed that the investigation had been assigned to them for further inquiries to be made. Contact made with the informant to establish the facts and consideration given to obtaining a witness statement, intelligence gathered on the subject, and a risk assessment performed should searches be required. Evidence collected to support, undermine the investigation by attending the office and retaining documentation. Consideration given to advising the financial investigators of the loss. Contact made with the subject either in person or on the phone seeking an explanation. Arrange interview under caution if suspected criminal offence. When you refer here to attending the office and retaining documentation, are you referring to the Horizon reports which could be printed from the counter in the branch?
Yes, documents that are on hand that have already been printed or provided by if it was an audit shortage, the audit team.
So you were looking at the record of the cash and stock which the counter-printed Horizon reports said should be in the branch against the record of what the auditors had actually found to be held in the branch. Is that right?
Yes.
Where there was a difference between these two records, an apparent shortfall, did you consider that this alone was sufficient evidence of a criminal offence to proceed to an interview under caution of a sub-postmaster or branch staff member?
Well, I think it would depend on the circumstances on what the sub-postmaster has said to us. So each case was on its own merits, really. So it may be that there might be an explanation for it, in which case there wouldn't be an interview, or it may be that they've admitted to something, in which case there would be an interview under caution.
So that seems like a slightly different process to what some other investigators have at least alluded to, where they've kind of almost arranged the interview under caution before they've even attended the office. Lisa Allen here seems to be describing the process, saying basically if there wasn't a reasonable explanation for the shortfall, which in and of itself would be hard if the system has produced an error, how would you be able to explain it other than maybe the computer's not working? It seems slightly subtly but more positively robust compared to the, well, we've been alerted to a potential shortfall, so we're just arranging the interview under caution now before we visit the office.
What about where someone hadn't admitted something and had given an explanation that you didn't, on face value, accept? Would there still be an interview in those circumstances?
Possibly taken into other factors that might have been evidence of false accounting or something along those lines.
Could we have the next page on screen, please? Paragraph 45. Here you say this: case papers were submitted to legal services for advice as to whether a case was suitable for a prosecution. The lawyer allocated the case would decide if there was sufficient evidence for a realistic prospect of conviction. If legal services recommended a prosecution, then the case papers were sent to the designated prosecution authority to decide if a prosecution proceeded. On authority from the DPA, the legal process would commence. Who acted as the designated prosecution authority?
It was a senior manager within the investigation team.
Did an investigator conducting the relevant investigation have any input into the decision as to whether someone should be prosecuted?
No.
Could we have on screen, please, paragraph 42 of Ms. Allen's statement? That is page 13. Here you say this: the contracts investigation would run independent of the investigation case. However, if the contracts manager decided that they would accept a repayment of a loss and not suspend the subpostmaster, then a criminal investigation would not ensue. Was a subpostmaster having made good an apparent shortfall therefore a material factor in decisions about whether that subpostmaster should be criminally investigated?
No, I don't believe it was.
The statement would seem to suggest otherwise there, wouldn't it though? Because I was reading to that where if they'd offered repayment and the contract manager accepted it, that actually we wouldn't proceed with the criminal case. Although maybe the part where she's saying, and they weren't suspended, is key there.
How does your answer fit with that paragraph in your statement? That if the contracts manager decided that they would accept a repayment of a loss and not suspend the subpostmaster, then a criminal investigation would not ensue?
Well, I don't think it would be right to prosecute somebody who we was employing.
So is it the fact of not suspending them rather than the repayment that you're referring to there as to why a criminal investigation would not ensue?
Yes, if the contract manager thought they were fit to still serve as a sub-postmaster and be employed, then we would not obviously prosecute. It wouldn't be right to prosecute somebody who was employing.
Well, she's right from the point of view that if you're prosecuting them for a dishonesty-based offence, then presumably you are at the point where you're saying the relationship, the implied duty of trust between employer and employee or sub-franchisee and franchisor has broken down, then you would expect a suspension and dismissal to occur before deciding to bring a criminal prosecution. That would make sense.
As far as you were aware, was repayment of an apparent shortfall a material factor in decisions about whether that subpostmaster or branch a subpostmaster should be prosecuted?
I don't think so, so people were still prosecuted who had made full repayment.
So it's kind of suggesting there that the thing is, has the breach of trust been so great here that we're going to suspend them, and if so, we can consider criminal prosecution. But obviously, this does leave open the kind of window for potential pressure on the subpostmaster to repay to potentially avoid criminal prosecution, even if they know they've done nothing wrong.
Over 2 pages, please, to paragraph 46. You say here, I do not recall the contracts manager having any input into the decision, and this is decision making about prosecution in terms of the context of the question you're answering. However, if the contracts manager decided to reinstate the subpostmaster, then a prosecution would not be deemed appropriate and would not proceed. Why would a prosecution not be deemed appropriate and not proceed in these circumstances?
Well, it's the same answer as before, really. I don't think we could prosecute somebody who we was employing. If it was that serious, then I think the contracts manager would have at least suspended, if not dismissed, and then we would have proceeded with a prosecution.
Do you ever recall a contract manager reinstating a subpostmaster and a prosecution decision being changed as a result of that?
I don't know.
In principle, who would reassess the position in relation to the prosecution in these circumstances?
Well, I think if an investigation was raised and the contracts manager reinstated the subpostmaster, then the case wouldn't go no further. It would just be no further action. So I would imagine that possibly the team leader.
And what about in circumstances where the criminal law team had already provided advice, for example, to proceed with a prosecution?
I don't ever recall the case getting that far.
So it sounds like maybe it was all a bit of a one-way process, in the sense of that there wasn't anyone ever kind of reinstated when a criminal prosecution had already been proposed. It was all one-way traffic. As soon as we think we've got the evidence from Horizon, they're suspended, and that leads on to dismissal.
To the extent that you can say, where no further action was taken on a criminal investigation, would a subpostmaster or branch staff member who had been suspended be reinstated in those circumstances?
Yes.